think we should start around 2:10. What do you think?
Hello, Miss TK. This is very okay with me. Thank you so much.
So we wait for 3 more minutes and then we can start.
That's okay.
Oh, it's time. What? Yeah, I've tried to put video. Not sure whether you are able to see me. Because I don't see myself. I don't know this technology thing.
Yes, we can see you. We can see you very
And
clear.
then are you able to hear me? Yeah, now from Rachel, then I think you are all able to hear.
Yes.
So good afternoon, everyone, and a very warm welcome to our webinar session this afternoon, where we are truly honored today to have this webinar session on ensuring institutional compliance with data protection law in Tanzania. This is a topic of immense and growing significance in our increasingly digital world. Data, as we all know, has become a new currency, and how we handle it is responsibly is not just a legal obligation, but a matter of public trust and integrity. We are privileged to have a high distinguished panel with us today. First, our esteemed moderator, the Honorable Judge Aisha Sinda of the High Court of Tanzania. Johanna, your presence here today underscore the judiciary commitment to uphold justice, staying abreast of the evolved legal landscape, especially in areas like data and technology. Karibu sana Mheshimiwa Judge. We are also joined by two brilliant and dedicated legal experts. These two ladies, I do admire them a lot. They are younger than me. I'm telling you, they've been mentoring me one way or the other. Maybe they don't know now, they know it. So we'll have Advocate Fatma Ngoro, who is also our board member, a high veteran tech and cyber security lawyer with a strong focus on data protection, regulatory compliance, and digital rights. Her work is at the forefront of policy and governance in the digital space, and I know our moderator will explain more. And then we also have Advocate Rachel Magege, a prominent lawyer with deep expertise in data protection, digital law, technology governance. She's an expert in helping organizations navigate the complexities of data private framework. This webinar is organized by us, the Tanzania Women Lawyers Association, an organization at the forefront of advocating for women and children rights, promoting good governance, and fostering the professional advancement of women lawyers in Tanzania. Now, why are we organizing this particular training? Is because, as I said earlier, nowadays you can't avoid technology. You just can't avoid. It's like money. Technology has become very important. Every day we have to use technology. We have our phone. We are on WhatsApp. We are on Instagram. We are everywhere. We are posting our pictures. Like now, I had to apply lipstick so that you see me like looking nice. Yeah. So you can't avoid technology. But at the same time, also technology has caused a lot of not a lot, I would say, okay, it's a lot, because now when it comes to GBV, gender-based violence that is happening in the social media, now it's becoming too much. It's becoming too much. And as you know, Taula, we are there to help the women and children. And the most people who are affected are the women. So having this particular meeting, it's very important for us as lawyers also to understand this particular law so that we are able to go and help those our clients, And so over the next hour or two, I think from now at 3 to 5, I think 2 hours and a half, we'll dive into legal requirement, the practical challenges, and the best practices for the institution to comply with Personal Data Protection Act of 2022. Our expert will shed light on why compliance is not just about avoiding penalties, but about building a foundation of trust with the public and stakeholders. Without further ado, I now hand over the virtual floor to our moderator, the Honorable Judge Aisha Sinda, to commence today's discussion. Your Honor, the floor is yours. Thank you.
Thank you so much, TK. Good afternoon, distinguished participants. My apologies, I will not be able to share a video with you because my internet is not that stable. Welcome to our webinar session on compliance with data protection law. As I was introduced, my name is Aisha Ali Sinda. I'm a judge of the High Court of Tanzania based in Morogoro, and I'll be your moderator for today's session. As our CEO TK said, there are growing concerns over personal privacy and data security, and in response, the government of Tanzania enacted the Personal Data Protection Act, number 11 of 2022, and established the Data Protection Commission in April 2024. This is a regulatory body overseeing the enforcement of the law and related regulations in Tanzania. And our data protection framework also aligns with regional standards like the East African Community, the Southern Africa Development Community, and the African Union. In this respect, you can see that the Tanzania's data protection ecosystem is increasingly robust. And as such, this Tauja webinar will examine personal privacy and data security laws in Tanzania, and will address the compliance strategies institutions should undertake and maintain, as well as the risks involved for non-compliance, including legal and reputational consequences. And before I introduce our speakers, I would like first to share a disclaimer regarding the content shared during this webinar. The opinions and views expressed by the presenters during this webinar are their own and do not necessarily reflect the official policy or position of TAWLA or the firms and organizations they represent. The information is provided for educational and information purpose only. It is not intended as a professional advice or as a substitute for professional consultation. You have noted that you are receiving a message that this webinar is recorded and only used for learning purposes and to share with members who may have missed the live session. The shared goal is that by the end of this webinar, all we will have a better understanding of the topic and enhance our general knowledge on data protection and privacy. We have two speakers today, and I will first introduce Advocate Rachel Magege. She's a lawyer based in Tanzania, and she holds expertise in data protection, law, digital and tech law, and regional data governance frameworks in Africa. She currently works at the Police Data Institute, leading several multinational projects with the African Union on improving data governance practices across Africa. Outside of work, she sits on the Board Association Limited Management Institute, Tanzania chapter. Rachel is also a well-versed legal author, public speaker, scholarly reviewer, and expert contributor with OneTrust Data Guidance, a regulatory research platform based in London, providing insights on AI governance, privacy, and latest trends on data protection. Rachel is a proud member of Tanzania Women Lawyers Association, TAWLA, and has been appointed to serve under the Data Protection and Privacy Committee of the East African Law Society. And our second speaker is Advocate Fatma Haruna Songoro. She's a seasoned technology and cybersecurity lawyer with a deep commitment to navigating the intersection of law and technology. She currently heads the Technology Law Department at Victory Attorneys and Consultants. Beyond her practice, Fatma is a dedicated legal researcher, collaborating with leading organizations on critical issues such as AI, digital rights, internet governance, child online protection, and data privacy. She's also a past research fellow at the Center for AI and Digital Policy and a past mentee in the Women in Cybersecurity Mentorship Program by Standard Chartered Bank and Strathmore University in Kenya. Fatma is also a co-founder of the DA Legal Hackers chapter, part of the Global Legal Hackers movement. This initiative brings together lawyers, technologists, startups, creatives, students, and scholars to explore the nexus of law and technology and develop cutting-edge solutions to pressing legal challenges. Her impactful contributions to the legal field in Africa were recognized in 2025 when she was named as one of the 25 women who inspired by the Institute for African Women in Law. Fatma serves in several leadership roles, including board member of Taula, director at TPPA, national representative of Tanzania at the International Bar Association, IBA, Young Lawyers Committee, board member at Tanzania FinTech Society, member of the Young Lawyers Committee, East Africa Law Society, and past chairperson of the Insolvent Law Committee at ELS. She's also an entrepreneur with the venture Huzuri Takaful Agents, an Islamic insurance provider in the country. So, distinguished participants, I have read the bios of our speakers, and I hope you agree with me that we have with us brilliant panelists to discuss this topic on compliance with data protection law. For housekeeping purposes, we'll first begin with the speakers sharing their views on the topic, and after which we'll open the webinar to input from participants. So I suggest that you put your questions in the chat box or write them down somewhere, and that you raise your hand to indicate a desire to speak when we get to the question and answer session. We'll try to get as many questions, if not all, as possible. And our presentation will be for 1 hour. So each speaker will have 30 minutes to the questions that will be posed to you. And I would like to welcome our first speaker, Rachel Magege, to respond to the pre-compliance and compliance issues. So welcome, Ms. Magege. And the first question to you is that to start us off, could you walk us through the first essential steps an institution should take when beginning its compliance journey with Tanzania's Personal Data Protection Act? What legal framework, regulation, policies should they be aware of?
Thank you so much. Thank you so much, Honorable, and thank you to everyone for joining us today. Yes, my first part, as you can see on the screen, is to bring a large reminder to all of us that on matters relating to data protection here in Tanzania, our first and foremost law is the Data Protection Act of Tanzania of the year 2022. So there's an English version, there's a Kiswahili version, so you can find it online, you can find it on the official website of the Personal Data Protection Commission, and it does give specifications and information on what all individuals or companies need to do as long as they're in the business of collecting and processing personal information. So that's the first law that you need to know and read and understand. So the Personal Data Protection Act of Tanzania also has subsidiary legislation, which are the two regulations. We have the data collection and processing regulations of 2023, and then there's also the complaints handling procedures regulation of 2023. Those are the regulations we have at the moment together with the law. And so the other component that is very important, Honorable, and for everyone listening, is to also be mindful and understand your sector-specific laws. Yes, so depending on whatever sector you're coming from, we've listed a few here. So it could be banking, it could be telecom, it could be insurance, it could be health. You may be working in the NGO sector. As Madam Tike said, Taula does a lot of work with women and children, doing a lot of work in the NGO sector. So it's very important to look into those specific sector-specific laws as well. So after knowing and understanding these different laws, the next step that is very important for you to know, I'll touch on this more specifically as we talk, but now generally is to also ensure that you have a data protection and privacy program within your institution. And this would mean having a data protection or privacy team also. I'll explain more of that along the way. But then also number 4, you need to make sure that you also know and understand the different stakeholders that you have or that are invested in your line of work, in your business, in your operations. This is very important because in one way or another, you will be sharing information with these different stakeholders. And so data protection is going to be very important for you to know and to understand. Also, what we tell people and advise people a lot in this area is that a lot of monitoring, a lot of revision needs to be done from time to time. In as much as we understand laws can be revised, laws can be changed, your internal systems in your organization, in your companies, they can also be changed. They can also be revised from time to time. That's very important for compliance and with data protection as well. So there is going to be a part that I will talk about the steps, each of the steps, especially with registration. One of the very important things for all of us to know is with Tanzania, the Personal Data Protection Commission does require every data controller, every data processor in the country to be registered with the commission. Now, for the benefit of everyone, what does a data controller mean in simple terms? And what does a data processor mean in simple terms? Yes, a data controller is the person who is in charge of the collecting and the storing of personal information, of personal data. Yes, so they're the ones who will give the instruction and the directive that we need maybe this much data from this village or from this region or from these groups of people. This is how we're going to store it. We're going to store it for maybe this many number of days or weeks and this and that. This is how we're going to transfer it and things like that. So that is a data collector. Some very simple examples that I thought I would share with all of you would be, for example, a university. Yes, when they collect information of students, registration, how many students do we have, how many courses are students taking, things like that. You would have a health facility which collects the information on different patients, what kind of illnesses or sicknesses are they suffering from, how often do they come. So they're collecting this information. These are the data controllers. They collect it, they store it, and they give the general directives of what this information will be done and how it will be used. Now, a data processor, in many times, a simple way to understand, a data processor is a helper. The data processor helps the data controller. All right, so the data processor would be the institution or individual that will take this information and analyze it and process it. Again, we're using the same word, and process it. And this is when you see different reports coming out, different marketing strategies coming out, different analysis coming out, because the data processor has taken this information, has analyzed it, has done all of these different processes, and has come out with some results from this information. Some very quick examples would be if you have a marketing firm. Yes, if you have an accounting company, it would be maybe even Zoom. Zoom processes a lot of our information, and we're using Zoom right now. So you may see that from time to time, different updates, different features will be added because Zoom has processed a lot of this information, and they've noticed, for example, we need to add language interpretation, or we need to add sign language, we need to add this and that. So these are just some few simple ways to explain and understand for people to know what a data controller is and what a data processor is. Yes, thank you so much, Honorable. I'm happy to continue with the other questions.
Thank you, Rachel. And my next question, you talked about registration. So my next question to you would be, how is registration done at the PDPC, and who is the data protection officer?
Thank you. Thank you so much, Honorable. And also, members in the audience, we will be sharing some links with you just for your learning and more information as we continue with this webinar. So one of the first things that the Personal Data Protection Commission of Tanzania requires is for each organization or company that is registering to make sure that they have a data protection officer. So this can be someone you appoint internally, or it can be an external person. It can be maybe a lawyer that you appoint externally, or it can be another company that you ask to serve as your data protection officer. And in simple terms, a data protection officer just means an individual or an entity that is going to be in charge of how all of this information and data is being used and collected and processed and stored, the entire life cycle. From the moment you collect this personal information to the moment that you close this file and say that we are done with this information, we've closed it, we've finished it. So that is largely the work of the data protection officer. They do a lot of work on compliance also, making sure that your company is up to date with the different laws, the different requirements, registrations, taxes, payments, requests, all of that. And so after appointing a data protection officer, the registration process is done online on the website of the Personal Data Protection Commission. There is usually a registration form. If you have not created an account with the Commission's website, you will be required to create an account there just for record purposes and to do your activities. And then you will fill in a form. And then after that, after you answer all these questions and show specifications of the data protection officer you've appointed, there will be different registration fees depending on your area of work and your different sector. So they range from around 100,000, 200,000 Tanzanian shillings, and it can go all the way to about 500,000 Tanzanian shillings. So this will be the registration fee. Yes, and then in terms of registering, it's also very important to know that you have to understand whether you're registering as a data controller or as a data processor, or are you both? Yes, in some entities or some organizations, you do find that you are a data controller, but you're also a data processor within yourself. So it's very important to know so that you register specifically for the certificate that you need. And at the end of that, the registration process, when all goes well, all documents are in place, you do receive a certificate of registration, which allows you to carry out this work for a period of 5 years, and it is renewable after every 5 years. That is according to the data protection law that we have and its regulations. Yes, so that was very brief, but that is how the registration process is being conducted, Honorable. And I've seen a question from the audience. Someone is asking if we're changing the slides. Yes, we are going to move to the next slide. This one was specifically here for the first 2 questions.
Thank you, Rachel. And my third question to you is on, once the institution has mapped its data and registered with the commission, what are the next operational steps, particularly around setting up internal structures and processes such as privacy programs?
Wonderful. Thank you so much, Honorable, for that question, which is going to take us to our next slide. Yes, and so now we are going to talk about the compliance itself now internally. Okay, you've already registered, you want to keep carrying out your work as a company, as an NGO, as an organization, but you also want to make sure you're compliant. So what do you need to do? On the screen, you will see that we have put on the left this cycle, okay, that has respond, assess, protect, sustain. So I am going to explain more of what that is. This is now going back to when we said the life cycle of data protection and data governance in general. From the moment you start collecting a patient's information, a student's information, a client's information, to the part where you have now closed that file and it is done, you no longer need that information, you've completed the purpose for which you collected that information. These are the 4 components that you need to know and you need to understand. Yes? So what they're basically telling you is, in terms of your compliance, you are going to respond, okay? You're going to respond to your organization's need on why you need this information, how is it going to serve you? Yes? You will be doing assessing the type of information you're collecting, the type of data you're collecting, how long do you need it? Is it sensitive data or is it personal data? Is it general data? After assessing, you are going to make sure that you protect this data. Yes, you can only protect what you understand. And so that's why assessing is very important, because that will allow you to even put this information into different categories, into different security systems, into different departments, however it needs be. So now you are going to protect this personal information. You are going to put systems that you need to have. You're going to maybe put the right people, the right heads of departments, and different tools, even different technologies, so that you protect this personal data. What are you protecting it from? You are protecting this personal data from unauthorized access. You are protecting this data from maybe system glitches, from human error. You're protecting this data from malfunctions, manipulation, from theft. Yes? So this is very important. If we can go back to the previous slide, I'm about to finish on it. Thank you so much. And then after protect, you are going to sustain. Yes? What does sustain mean? Sustain means looking at how your program, your department, your institution is going to keep this protection alive and well and thriving for years and years to come. Yes, whether it needs another monitoring plan, whether it needs another revision plan, how are you going to sustain this entire program, this entire cycle? So there are different systems and there are different methods that you can use. And so with compliance, one of the things that is very important to know and to have is consider having a data protection and privacy team. Yes, this could be under the data protection officer. If your company has enough staff, you could create a sub-department or a subdivision and say this will be our data protection and privacy team. However, if you have a smaller organization with maybe not much staff and resources, you could just maybe give this to another department, or it could be one person in charge of this entire program. Yes. In many examples, what other companies have done is the data protection and privacy team would fall under maybe the legal department, or it would fall under the compliance department, or if you have a monitoring and evaluation team, it could fall under there. So depending on the type of work you do, depending on the resources and the staff you have. So having this team is very important because they are the ones who are going to look at compliance and risk. They're going to create training programs, as you see here on the screen. Yes, it will be a data protection officer. Compliance, they'll have a compliance and risk team under them. They'll create different training programs for employees. Yes, but they'll also assist and have these data inventories and records, and to keep these records properly organized. Because at the end of the day, it is important to make sure that you know and can access, for the people who are authorized to access, where this different information is from. Yes, so that it's not disorganized and so that it's not getting lost. And then, as I had mentioned, you have assessment. Now, assessment also goes much deeper into impact assessment. One of the requirements from the Data Protection Commission here in Tanzania is to submit quarterly data protection impact assessments. This is still being new and it's still being monitored and tested. Over time, it may change. Maybe the frequency of it might change, it might reduce, and it might be maybe twice a year or once a year. But a data protection impact assessment is very, very important, because what you're essentially doing, for simple language and for the benefit of everyone, you're looking at the type of data that you are collecting and its impact on the person, on their integrity, on their privacy, and how this will affect them. Of course, you need to think, God forbid, should anything go wrong, what is the impact of this? Am I complying? Am I following regulations? Am I keeping with times, with how technologies and systems are changing? So it is very important to have a data protection impact assessment, and these are reports that you prepare. The commission requires for them to be submitted to the commission from time to time. You can have a vendor assessment too, because you will find yourself and may find yourself working with third parties, yes, who at some point may need to access that personal data that you have, whether it's data of your employees, data of your clients. If you have a vendor who is maybe a payroll company, if you have a vendor who brings maybe a new HR system, new technologies, new security features, these are all third-party people. And so it's very important to do this assessment. And then you have these different privacy programs and policies, very, very important to know. And then also the training and awareness. You'll get to establish metrics, monitoring and auditing systems. Very important. You need to monitor yourself. You need to monitor your team and employees to see how well are they performing an understanding of data protection. And one of the things that is important in the monitoring and audit systems is you can even conduct what we call simulation exercises. Yes, so this can be like a mock trial or a mock exam, but it's a surprise. So I've seen a company where the IT department would send out maybe a scam email or something like that, but you wouldn't know. And they've had people, even managers, even CEOs, click on that link and share their information. So when they would regroup as a team, they would say, hey, this was an exercise. It was just a surprise exercise, but we've seen our manager, our head of department click on this. And if this was real, if this was actually happening, then it means you've just given your data to a scammer, to a hacker, and different things like that. So this is an idea. Please try doing this with your companies and see how well your team and your employees respond to a surprise email or a surprise announcement. Yes, and then of course the last thing will be handling data subject requests, handling complaints, and ongoing compliance. When your clients come to you, when your customers come to you asking for their data, asking for changes to their data, maybe I've changed my address, can you change it now to this and that? Or even if they have complaints, these are all things that would best be addressed by having that privacy or data protection team or that privacy or data protection person handling all of this information. You will also get to hear from my fellow speaker, Fatma, more in depth on breach preparedness and responding. You really, as part of compliance, you really need to prepare for the worst in case it happens. You need to prepare on how you will address a breach, if a breach happens in your institution, in your organization, if any incident happens that compromises or steals or manipulates the personal data that you have, how will you respond? How will you address the data subject? How will you compensate these people if need to be compensated? How will you respond to media? How will you communicate? So all of these are very important. Honorable, thank you so much. I have answered that question in depth. Thank you.
Yeah, thank you for a very elaborative answer on the operational steps to be taken after registration with the Commission. Now, we would like to understand what are some common mistakes or misconceptions that Tanzanian institutions are currently making as they try to comply with the law, and how can they avoid these pitfalls?
All right, thank you so much. I'm happy to address that. And my apologies, I misquoted in my previous explanation, just to clarify. So with data protection impact assessments, those are specified scenarios. What the Commission here in Tanzania requires are compliance reports. Please, my apologies for the wrong wording, are compliance reports. Data protection impact assessments come up in other scenarios, and we will get to understand how the processes work for that. Thank you so much. And so some of the different misconceptions that I have heard and seen, some people believe and have said that data protection or privacy, all these requirements, they're not really important for how I'm going to make profits. They don't really affect how I'll make profits. That is one misconception, and I am going to say that it is not true, because the more trust you can show clients and customers, if you can show a client that you can trust me with your sensitive information, you can trust me with your financial data, you can trust me with your health data, your chances of making profit, even financial profit, whatever profit, your chances go higher, much higher, if you can show that there is trust and you are complying with the laws, you are complying with all of these privacy and data protection systems. It's very, very important. I've heard other misconceptions that have said, or conversations where people have said, you know, data protection tends to really favor the data subject more. There is nothing for data controllers and data processors. It's completely against us. I would like to tell everyone listening here today, if you have heard something like this, that is not true, because data protection laws and systems, even the one we have here in Tanzania, does allow a data controller or a data processor to still conduct their business, to still make profit, as long as you're obeying the laws and as long as you're doing it legally and ethically. In other learnings and writings, they do inform that a data controller, a data processor has the rights to collect data, the rights to transfer, the rights to store. So these are methods and activities that are protected. You are protected as a data controller and a data processor to be able to do these things. I know specifically in Europe, for instance, where we have the General Data Protection Regulations, a very large instrument on data protection, at least for the European continent. It does talk about that and also highlights more of these enablings for a data controller and a data processor. So at the end of the day, the law is protecting the data subject, but it's not fully looking at the data subject and ignoring the data processor and data controller. More responsibility is placed on the data controller and data processor, because they are the ones handling this data and information, which is very, very sensitive and which has an abundance of wealth and opportunities and possibilities. And also, last but not least, there is misconceptions on consent. Consent is a very, very big thing. It's one of the principles in data protection, where a data controller and a data processor are required to get the consent of the person whose information that they are taking. Now with consent, and I have heard this, I promise you, where some people would say, okay, we got their consent, now we can do anything, we're free to do anything. No, with consent, you have to still make sure that you are using the person's data ethically, responsibly, and according to the agreement and according to the scope of your ask of that data, according to the time you said you'll use that data, according to the purpose of which you need to use that data. And also consent can be given, but it can be withdrawn also, and that needs to be respected. The data subjects, the request to withdraw their consent needs to be respected. And so there's so many examples and so many misconceptions. We really just do hope that people, everyone, organizations, companies, businesses, everyone listening to us here in the audience will be able to make sure that they get true professional and even legal compliance help whenever they're conducting all of these different activities, just to make sure that you are obeying, you are complying, and that you're also protecting your business, you're protecting your reputation, and also your dignity. And also there is a quote in the next slide. If I may just see the next slide, there is a quote we had prepared for all of you. This is by Anne Kavaukian, and she is one of the experts in data protection from the West. And she says that privacy has historically been viewed as an impediment to innovation and progress. But that's so yesterday and so ineffective as a business model. Without user trust, technologies cannot move forward. So Anne Kavaukian is still emphasizing this point that privacy and data protection should not be viewed as stumbling blocks or challenges or dead ends to one's innovation, progress, and even profit making. Yes, in fact, it's the opposite. It actually accelerates and can improve and grant you greater success and profits in your endeavors and in your businesses. Thank you so much, Honorable.
Thank you, Rachel. And my final question to you is, for institutions that have taken initial compliance steps, but want to move towards sustainable, ongoing compliance, what security measures, strategies, or tools would you recommend for monitoring, auditing, and staying up to date with evolving regulations?
Thank you so much. I'll be just very brief with this one. So apart from what I have just said on having a data protection or privacy team, which is very, very helpful, security measures are very, very essential to your organization. So for example, you can put, the physical security measures, the usual, having CCTV cameras, maybe having fingerprint access to certain rooms or locks or places like that, or even just having a custodian, depending on your business and depending on your area. So these are some of those physical security mechanisms that you can use, but you also have the other maybe electronic securities you can use, maybe password requirements for certain devices or for certain folders and files, all these different systems that you can use. But all of this is for the protection and for the security of this data that you are having. Because remember, a data breach and a data incident, these are two different things, can happen even just because of unauthorized access. Yes, whereas a data breach is looking at fully intentional unauthorized access, where a person fully intended to have unauthorized access to this information and then use it for negative or illegal things. Whereas a data incident is more subtle. It could be human error, just a system glitch. And so those are the main differences. So you do need to have these very important systems in your institutions, in your organizations. It also helps for you to have different consent management frameworks in your institutions, just for information that you give to your clients or customers or to your different beneficiaries. It also really helps to have a privacy policy. Now, very important for everyone to know that a privacy policy is different from a privacy notice. A privacy policy is internal. Yes, it's for your team, for your staff, for them to know how this information is used, what not to do, what to do. And then a privacy notice is external. It's what you put on your websites, it's what you put to your customers, to your clients, to vendors, to people who are visiting you from the outside, for them to know that this is the information we're collecting, this is what we're going to do with it, this is how long we're going to do with it, this is how we promise to protect and honor this information. So these instruments and these documents are very, very important to have. And if you already have one, it's also good to revise it, to renew it, and check that it's complying and staying up to date with the relevant laws and policies and systems. And so with monitoring and audits, I'm not able to exactly specifically say this and this tool. I know it's something I'm also still learning, the technicality of these different tools. I'm happy to share some resources also. But basically what they do is to make sure that you are assessing your privacy program, your data protection and or privacy program, your team, your staff, your systems, your security features, all of that from time to time, and you monitor how they progress and how they perform. And then you also do an auditing so that you know what needs to be improved and what needs to be changed. These are the systems that can really, really help. But at the end of the day, let us all remember that data protection and privacy, when you're working in your organizations and in your companies, you want to make business, you want to bring more clients, you want to bring more profit. It is very profitable to invest in data protection and privacy. It is a very, very big investment that is worth it at the end. And looking at the current state of the world, looking at the current state of technology, it is worth investing as of yesterday. And it is worth investing to stay ahead of the times and not to wait, for example, for a breach, an incident, a disaster, not to wait for that. So I am very happy to keep answering any questions you may have at the end of this presentation. And we will be sharing more resources in the chat section as well. Thank you so much, Honorable. And thank you everyone for listening to me.
Thank you, Rachel, for a brilliant presentation. And my key takeaway from your responses is that in this digital era, user trust, consent is very important for technologies to move forward. And we have seen recently the Commission has fined some organization and individuals for using photographs without the person's consent. So my distinguished participants, let's give a round of applause to our speaker. You can go live or use the clapping or applause emoji in the chat. Thank you. Thank you, Hanifa, Monica, Lucia, Divine, Elena, Neema. Thank you all. We appreciate. So you did a good job, Rachel.
Thank you so much.
Thank you. I can see Sam, Josephine, Tike. Thank you, thank you. Now let's continue on our second part, and we'll explore on how to respond to incidents and breaches. And our speaker for this session is Miss Fatma. Karibu, Fatma.
Asante Mheshimiwa. Thank you so much. I'm happy to be here.
Yes, Fatma. To begin with, how does the Personal Data Protection Act define a personal data breach, and what types of incidents would fall under this category?
So thank you, Honorable, for that question. Maybe let me start.
Apologies, Fatma. Apologies, just a second. Yes, I've seen some few questions on the chat box, and we will respond to these at the Q&A session. So if you have anything, just put it there. So continue, Rachel. Sorry, Fatma.
Thank you, Honorable. So I will begin maybe by explaining the difference between a data incidence and a data breach. When we talk about a data incidence, we're talking about any unplanned event, emergency, or disruption that can happen to a company or any entity's operation, system, services, or asset. And normally it results maybe to a system failure. It can result into a breach. It can result into service disruptions or other events that normally are a result of that. And so ideally, incidents is any event that affect, I would say, an organization, and even more specifically, when it comes to data security, it's more about how the incident affects either the data security, confidentiality, which with confidentiality is if you're an institution and you hold someone's personal data, ideally, confidentiality should be there on who accesses that data and how that data is being maybe shared. And so that's the aspect of confidentiality. I think anyone who has the understanding of cybersecurity, the KIAD is one of the common, I would say, like aspects. So there is confidentiality, there is integrity. And when it comes to integrity, it means that the data that you're holding is actually correct. It's not been altered. It has not been manipulated. And when it comes to data protection, we know there are principles with regard to data accuracy, with regard to ensuring that you have data that is actually fit for the purpose that you want to use. And so that speaks to integrity. And then there is availability of data, which normally this means that imagine you have maybe you're providing certain services, and then some sort of data is not available. I think, for instance, recently CRDB was changing their system, and I think some people are complaining like they could not see maybe their bank statement, they could not see this. So that could be an incident because now the data is not available like for your users, for your customer. And so ideally that's an incidence or a data incidence in this context. However, when it comes to a breach, when we speak about a breach, we normally refer to a confirmed event whereby personal data has been accessed, disclosed, altered, lost, or destroyed. And normally it's without justification or lawfully. And so let's assume that you have someone's data, and then someone hacks into your system, and then they can now see that some people's personal data, they can misuse that data. That becomes a data breach. And so all breaches are incident, but not all incidents are breaches. And I think this is quite a big foundation for everyone to understand. And ideally, maybe for like for your envisioning, assume we have a building. There are normally fire alarms in case they detect smoke. So the alarm can go off. That will be like when there is an incident. However, it doesn't mean that maybe there is actual fire. Like sometimes there is no actual fire and then the alarm can go off. And that is like how I would say incidence is. However, when there's an actual fire, that's a data breach. Like you can see here is fire, like it's confirmed. And so that is, I would say, an explanation to those two terms. And then now moving on, Honorable had asked me if the law, and specifically the law in Tanzania, defines a data breach. If you read the law, if you go to the interpretation section, there's nowhere that data breach is actually defined. However, in our law, we have a principle of security, which is established under Section 27 of the Act. So if you go to that section, the section has put an obligation of security and has provided some aspect that would fit into the definition of a data breach. I think I would like to point out, if you read that section, the section specifically is speaking to a data controller and their representative. The previous speaker, Rachel, had explained the difference. So if you're a data processor, I don't think that part actually refers to you. And I will explain this later, but it's critical to understand that there is a reference to a data controller and his representative, whereby the representative or agents could be the data processors, that they have an obligation to ensure security standard. And then when you go further, it says that those security standards are set to ensure that certain circumstances are protected. And these circumstances, when they happen, is what will result into a data breach. So one, the law says that the first scenario will be in case there is negligent loss of personal data. And I know most of the time when we speak about data breach, people tend to think that maybe it happens in systems only, but let's assume that your company and someone comes and steal your maybe laptop or your device or a certain item or your file, like your physical file. You wake up one morning, someone has raided your office. They have taken all your files and all the records for your customer. That is a loss of personal data. That is a data breach already. And so the law speaks to that amounting to data breach, whereby there is loss. And then the other one that is mentioned, it speaks to having to unauthorized destruction. And so if you have people's personal data, and then for some reason someone comes and destroys them, or a hacker hacks into your system and destroys your files or your backup, then that's a data breach. And even when maybe someone physically destroys your asset, your IT infrastructure, it can result into a data breach, depending on what infrastructure and what system. And so that's the other aspect of data breach definition, which forms, I think, part of that definition. And then the other one is whereby there is alteration. And this is unlawful alteration, because if you're holding someone's personal data, it can be altered. But there are scenarios whereby someone can alter that data without your permission or without your consent. And so when alteration happens into the data, it means you do not have accurate data. It means maybe the data that you're actually using is not fit. And so that's also another aspect that is considered as data breach. And then the other one is unlawful access, I would say, to personal data. And this normally happens when someone maybe has access to a certain kind of information that they're normally supposed not to have. And when we speak about unauthorized access, I think it's important to note that sometimes someone within the office could be accessing certain information or certain document that they should not be accessing in the first place. So I think I remember there was an institution, I wouldn't refer to the name, but I think they were doing like a system change. They did their changes, and I think there was something that had to happen in the system, and they had like a master key. And that master key was given to a person. Ideally, the person with the master key could see every customer's account, like they could do anything. And they were supposed to fix a certain thing, and then access would be revoked. So in the process, when the person was trying to do what she was supposed to do, she had a colleague whereby she had asked for assistance and then given access to that colleague. But the office just knew they gave access to one person. So when the task was over, access was taken away from the first intended person that was intended. However, the second colleague still had access, and then he went on and did malicious activity. So even when the company came to discover it, they actually thought it was the first person who was given access that was doing the malicious activity, misusing data, and getting certain benefit out of that data. However, it was actually a colleague, and this speaks to having unauthorized access. And sometimes I know in offices, you might be just sharing your password without knowing that someone can maintain that password and maybe access certain data that they're not supposed to do. And so those instances that are actually highlighted in the law under section 27(1), are actually what I would say determine a data breach. And I think if you read the law also under that section, it's actually the section which mandates that you notify the commissioner in case of any security breach. And if you read the law, you would notice the law says that when the breach happen, either it's being processed by or on behalf of the data controller. So this means if you're a data processor, you'll also fall into the requirement of notifying. And maybe just to further explain with regard to data breach specifically, around the globe, it is said that data breaches are mostly caused by malicious incidents. We know of phishing event and social engineering, and with AI, there's quite a growing number of these phishing scenario. Rachel had spoken about it, and other use of AI to malicious access data and result into data breach. And mostly it's due to stolen or compromised credentials. And then I think the other one that comes is human error. So human error is also one of the causes of data breaches. And then we have system glitches that can happen maybe to unpatched software or like other incidents with regard to the system. And I think maybe I'll end my, so I remembered, I think, Honorable, you had asked me like classification. And so there are different ways in which incidents or breaches are classified. Sometimes they can be classified according to impact. So you will see most organizations, they have like levels whereby if a breach happened, it's considered critical, and then maybe it's considered high, and then maybe it's considered medium or low. And this means that the obligation, let's say, to notify the commissioner, the obligation to notify the data subject will depend on the impact, whether it's critical, high, or medium, or low. Because sometimes you can suffer a breach and maybe it's not even notifiable because of the impact that is very low, or like you've not suffered an actual impact that requires you to notify. And so that is one way in which breaches or incidents are classified. And the other one is normally according to the source. So if the source is an external source, maybe you have a third-party vendor who has resulted into the breach, or sometimes it can be an internal person, as the scenario had given. So we have insider threat or users, actors who can result into breaches, who can cause breaches or incidents. And then the other classification is normally accidental kind of incidents or breaches, and the last one is maybe because to environmental. Sometimes you would find maybe there is a natural disaster and you suffer an incident or a data breach, but it's actually caused by an environmental crisis. And so that is also a classification of data breach depending on the source that is causing the incidents. I think I'll end there.
Thank you, Fatma. And my next question to you would be on what are the immediate steps an institution should take once a data breach is suspected or confirmed, including internal response protocol and external reporting requirements to the Commission?
So thank you. I think when it comes to incidents response, I would start by saying that handling breaches is normally quite successful if there's preparation and planning for it. I think when we speak to the Tanzania context, a lot of organizations, unfortunately, maybe do not even understand or do not even have a plan, or they do not have a focus into breaches. However, it's normally said that with regard to data breaches, it's not a question of if it will happen, it's actually when it will happen to you. Because the rate of breaches happening is quite high. And so with that said, I would say if an incident has happened, the first step will be the first person who noticed or detects the incident. That is ideally normally the first instance. And so it might be your customer who maybe is experiencing a certain glitch, or it might be someone inside the institution that noticed something is wrong. I recently had a customer, they suffered breach. It's just that one day the employees came to work and they were trying to access certain files and they could not. And so they reported it to the IT person. And so normally that is like the first step of detecting the incident. However, the best practice in detecting incidents is also doing your audits in your system and assessment in order to detect if there are any incidents or if anyone is accessing your system unlawfully. Because sometimes breaches happen, and globally it is said that it takes, I think, around 240 days for someone to detect that there is a breach. So the IBM does a report on data breach each year, and that is the estimate of days. So you can imagine 245 days for you to detect that you're facing a breach. Imagine how the hackers maybe accessed your data or used or the damage that they have done. And so incident detection is processes is also quite a critical thing. So moving on, I think one, as I say, detecting the incidents. And then after that, normally someone would report to the IT, to the data protection officer, whereby there has to be a confirmation, specifically for data breach. I had said before, sometimes you can have a data incident or you can have a breach which is maybe not notifiable, it's not. So once the breach is discovered, you need to confirm if this is a data incident or if this is a data breach. And if it's a breach, normally that is where the requirement to notify comes in. Because if it's maybe just an incident, you might not be required to notify. And so even confirming, some institution, especially international organization, would normally say in the policy, maybe it will be a legal person who confirms if this is a data breach. So they have like an incident response team whereby it will have maybe the DPO, people from the IT department, a lawyer, and they will have to confirm first if it's a breach. So it's quite an important step because it actually determines what you do next and how your responsibility and liability. I think after you have confirmed, then you move to a process that I would say is now investigating that data breach. And ideally, this means that one, you isolate the system or the server that is actually maybe damaged. And so sometimes you'll find maybe people will shut down their servers or would ideally eliminate the either system or the application or the files that have been maybe accessed. And so that is one step whereby you isolate. And then the other one is now containment, whereby you try to ensure that the breach does not spread into other system or into other files. And so that is the other thing that is normally done in investigation. And then you move on to eradication, which is normally now ensuring that you're trying to handle the incidents and resolving or eradicating it. And then you move on to recovery. And so that is also part of the investigation. And sometimes this, like, it doesn't have to be very, like, from one stage to the other. Sometimes things could be happening across different levels or different stages. The other key thing to do is actually notify or cooperate with the key necessary party. Sometimes a data breach could have resulted from a vendor, and maybe it's not in your system. And so much as you're the data controller, you're the one who is responsible for that data, but now maybe the systems are not yours. Or sometimes we have seen incident happen and maybe a group of companies have their server in one specific location. So the incident has happened in another jurisdiction. You're a company sitting here in Tanzania. However, your data has been breached. And now you need to cooperate or have your IT people here, your DPO here, cooperate with the team sitting in another jurisdiction to kind of try to resolve the situation. And so that's also an important part of it. And then the other one is you move to incident impact assessment. And when we speak about impact assessment with regard to data breach, this is when you analyze the extent of the breach. So maybe how many data or how many files were accessed, how many servers were destroyed, or if maybe someone has destroyed certain of your IT asset, like how many are they? So you do an impact assessment of the kind of things or that have been destroyed, or data that has been destroyed in the data breach. And so this helps you to understand the kind of exposure. It helps you to understand the kind of damage that you're currently suffering from the breach. And it will also assist you on how you progress with your incident response. The next step is actually to do internal announcement. Most of the time, it's a good practice to once, when the incident happened, normally there will be an incident response team if the company has the policy, if they have structures in place, and ideally, every company should. So normally, the initial processes might be done maybe by the incident response team, and the management might be informed, but maybe not everyone in the company might have known, or every employee. So now you can notify other employees that we have suffered a breach. The breach has affected 1, 2, 3 initially, like we're still confirming maybe, and we're doing 1, 2, 3 so that your staff can also be aware if they have to be more vigilant, if they have to maybe, if there's anything they need to be more concerned to check into their system, if they have to change their password, if they have to do anything, then it's also a good time to now encourage them to do it. And then I'll say the other step is now moving on to notifying the commission. And I think normally it is within 72 hours from the time you detect the breach to when you're supposed to notify the commissioner. And so the commissioner has a form, a very detailed form, and you'll realize if you go through the breach notification form that you are required to disclose the amount of data that was breached. You are required to disclose the type of data that was breached. You're required to disclose what caused the breach, where, how, and all this information. So the initial step that I was discussing too would assist you with ideally getting the information. Sometimes people suffer a breach, and maybe because they don't have yet all the information, they think they could take 1 week to notify the commissioner, and that is wrong. And sometimes I have a situation whereby I have a client, they have a policy, but I guess no one ever cared. So they suffered a breach, I think 4 months later, they're telling me, so this happened. And I'm like, why didn't you say it within the 72 hours? And they're like, we didn't know. And they're like, oh, we have a policy. We have an incident response team that we're supposed to form. So it's one thing to have your policy, it's another thing to actually understand them. And so because the notification to the commissioner is a legal obligation, there might be implication for late notification. And so it's quite critical if you are assisting any organization in breach to always, or even in compliance, to tell them that if there's a breach, 72 hours, it has to be notified. And then there's normally sometimes a requirement to do forensic investigation, which is normally a more detailed investigation and into the system and clearly finding what really happened and having a report. Sometimes people use internal people maybe to do the forensic, and they do not want their own internal people. Sometimes people can use the internal people if they have the capacity to do that. And then the other one is monitoring the breach. I think this is also, as you start handling the breach, you also have to monitor if you have truly maybe blocked access, if you have truly maybe secured your file. Don't do it just once and then assume nothing is happening anymore. Sometimes you might find out that you have removed access from the malicious actors, but maybe someone is still accessing it. So you have to monitor and all that. And then there's having your business continuity plan, which normally most businesses would have, on how to continue with your services without disruption, and how you continue operating, and remedial actions that you can take. And I think the other step that is quite important is actually documenting and preserving evidence while you're doing all this step handling your incidents, because while you're making your report to the commissioner, you'll be required to do that. And so I had just highlighted also part of like breach recovery. Once maybe you've handled your breach, normally people would do like an evaluation to understand maybe if we did suffer an incident, whose credential was actually breached. And so you just do an evaluation and assessment. You quantify maybe the cost. If you were told to pay fines if you're told to notify the data subject. I don't know if I mentioned, but yes, so sometimes depending on the breach, you might be required to notify the data subject, and you might inquire costs to now notify these data subjects. And so you look at all the cost, all the damage you have to incur, because this is also part of learning and improving your cyber resilience, or like security resilient. And also maybe another thing, I think even the commissioner here requires every organization to have a breach register. So there's I think a template that's available whereby every time you suffer a breach or an incident, you document it. And so you're able to tell maybe if we're suffering breaches, it's due to this or due to that. And then the other one is understanding if your data protection of the institution, you need to understand the benefit. So normally, most of the time, Rachel, I think, was speaking to that. Most people sometimes find data protection, cybersecurity, something that they don't need to invest into. But normally when a breach happens, that is when the company or the institution are willing to invest into the IT, into the security, into data protection. And so most of the time people would also use that opportunity to kind of speak to the management, to people who are making decisions to invest more into their maybe incident response or into data protection, privacy, and security. And so I'll end there. I think for anyone who would like further to maybe understand, there is a NIST framework, NIST framework, and SAN framework. So these are two frameworks that have very detailed steps on how to handle incidents. I will end there. I think I've spoken for quite some few minutes.
Yes, thank you, Fatma. And just for housekeeping purposes, before we proceed, if you check on the chat box, Ms. Magege has shared the link for the English version of the Data Protection Act. And I think there is a message from Mary Richard. Thank you, Rachel, for thoroughly and eloquent presentation. And there's also a message from Lucius Bati Njiti. Well done, Ms. Songoro. Nice presentation. So I hope, Ms. Fatma, you have breathed a bit and you have talked about the Data Protection Officer, DPO. And now could you elaborate on the role of the DPO in breach response? What specific action should the DPO lead, and how should they engage with affected data subject and the Commission?
So thank you, Honorable. I think when it comes to the DPO, the Data Protection Officer is quite a key player, I would say, in incident response. And if you read the Act, the Personal Data Protection Act, Section 27, subsection 3, it actually says a data controller and processor needs to appoint a DPO who shall ensure that there are control and security measures in place. And so you would clearly see that the law is putting an obligation on the data protection officer to ensure that there is enough security and control. I know now most of the lawyers are probably acting as DPO for various company. If you are, or even if you're not a lawyer, as long as you're a DPO of a company, you have the responsibility of ensuring security and standard. And so the role of I would say of a DPO would normally start from the policy. Do you have your access control policy or protocols in place? Do you have your incident response plan? Do you have your data security policy? And so policy is one measurement that can assist. And so as a data protection officer, you need to ensure. And then we move to preparation. Rachel was giving explanation on stimulation exercise, on conducting tabletop exercise, in trying to prepare your team. And so they say, as I had said previously, if an incident happened and you had never prepared for it, you had never planned for it, you have already failed in handling that breach. And so as a DPO, you need to build that culture of the preparation, of the trainings. I know of a company that normally has every week they meet at least even for 15 minutes, all staff, and they do like an IT or cybersecurity or data protection drill just to ensure that there is that culture and everyone is staying up to date. Sometimes they keep each other informed on what is happening, if there may be breaches that are happening from global to local. And so that is just a culture that a DPO can play in ensuring they're properly managing data breaches in the organization. Another role, when the incident happened, as I previously said, most of the time it's the DPO, maybe with the legal or the IT people, that will be the one who declares that this is a data breach. And so meaning that there is already a legal obligation maybe to notify if it's notifiable. So that is also another role. And so if you're a DPO, you need to understand what kind of data breach are notifiable, what kind of maybe incidents or breaches can maybe not, maybe they're very low risk, and so they're not even supposed to be notified. And then I think the other role that a DPO normally plays is coordinating response. So we have spoken on notifying the commission, we have spoken of notifying data subject, we have spoken of notifying the employees or other stakeholders. Sometimes you might find you have service provider that maybe you might have to notify. So the DPO has a role in coordinating responses, in ensuring that there is consistent communication with how that notification is given. And I think even when you look at the form by the commission here in Tanzania, it normally requires you to state the notice that you gave to the data subject. What did it say? Because it has to be a sufficient notice that you have clearly said what has happened, the measures maybe you have taken, the kind of data, and how you've warned or alerted your data subject or your stakeholders on how they need to prevent or prepare themselves in case they are maybe attacked because of their personal data that has been breached. And so that's also coordinating the response is also a role that a DPO has to play. And then similarly ensuring that the reporting is done as per the agreed framework and properly done, to ensure maybe the commission doesn't want you to provide more information or come to you maybe wanting to do investigation to audit your system. So all this can be done if your DPO can properly do your reporting and fill in your report and ensure as per the standards. I think the other role of the DPO is documenting the data breach handling and ensuring that if there's a root cause analysis done, there's a report. If this is done, there's actual documentation to show for compliance. I also think post-incident, trying to assist with the recovery, maintaining the registrar that I was speaking to, all these are obligation that the DPO is supposed to play. And even when you read the regulation that state that every data control imposter should have a data protection officer, it clearly states some of the roles. And this data breach and incidents response is part of that obligation that they have been given. And so I'll end there.
Thank you, Fatma, for your response. And my last question to you would be, what are some realistic challenges institutions in Tanzania face when responding to breaches, and how can they build resilience against future incidents?
So thank you. I think when it comes to challenges, a lot of institutions, as I've said, they lack preparedness. So when the incident happens, they're not prepared. It takes time to coordinate. It takes time to even know who is supposed to be doing what, who is supposed to be approving, who is supposed to be making the notification. And so that is one of the challenges that most institutions face. I think the other one would be with regard to maybe security standards. So internationally, there are security standards that are set. But if you look into the current data protection framework in Tanzania, the law has just maybe required people to comply with certain security measures, but there are no clear standards that have been set or guideline. I think the law under section 64, if I'm not mistaken, which empowers the minister to make regulation, has stated that security standard is one of the items that the minister can make regulation on. And so I think if there are security standards that are set by the commissioner to fit our local context, because sometimes this international standard seem to be very costly, and most organizations, especially small organizations, struggle maybe with getting their certification or those standards that most international global entities will be. So I think the other challenge is the lack of security standards that are clearly established here in our local context and can guide data control our processes. I think the other challenge would be the generally low awareness on how to detect breaches. So I think most institutions are suffering breaches, but they don't even know. They hardly know. And for African countries, it's actually said that there is quite a growing targeted cyber incidents and data breaches to government authorities. A lot of cyber criminals are aware that there is lesser protection and safeguard in most entities in Africa. So a lot of them are looking and trying to access system from government to private institutions that are collecting data. And it's unfortunate that most of the time, we normally don't know. I think this year in April, the Moroccan institution for pension suffered a very severe data breach. And you can imagine, I'm not so sure the specific kind of breach that they had suffered, but it was confirmed that it was a data breach. But imagine you wake up one day and then maybe PSSF or NSSF has no record of any pension of anyone. Like, where would we begin? And so there is quite a huge cost on data breaches, and everyone has to really pay attention. And so the need for that, the need to understand is quite lacking, and it's quite worrying, especially in the times that we're all moving into the digital world. I think the other one will be infrastructure and expertise challenge. There's quite a gap there, but I would end there.
Thank you so much, Fatma, for a very well prepared presentation. And my take from your session is that institutions need to be prepared on breaches, and they need to report them accordingly and understand the law. It's very important to have PDOs in place, and with the advancement on the use of AI, it's very possible for lawyers in here to upload sensitive client information, contracts on ChatGPT, and the next day you just find the information out there. And this was supposed to be confidential between the client and the firm. So I believe that this topic is very important now, especially for us lawyers. And I would like to ask you, the audience, to give a very big round of applause for Ms. Ongoro. Thank you, Sarah, Samuel, Ibrahim. Thank you, Christina, Ibrahim. Thank you. Now it's an open floor discussion. And following the discussion and insights from the panelists, I would give those who wish to participate an opportunity to drop a question, recommendation, advice, whatever, on the chat box. And we'll take those first rounds of question. And I would appreciate if the submissions or questions are concise and precise. I've seen that Ms. Rachel was responding to some of the questions. So let me go through them and see. The first message is from Mohammed Lukwaro. Another issue relates to the type of personal data displayed on official documents such as the NIDA, NHIF card, and similar documents. These cards often include sensitive information such as a person's full name, date of birth. I question whether it is truly necessary for such details to be viable on the face of the document, as this increases the risk of misuse or identity theft. Could the law provide clearer guidance on why this information must be displayed and whether alternative approaches such as limiting visible details while keeping full records in secure database would better protect individuals' privacy? So that first question is from Mohammed. The second question is from Raymond Cosmas. What are the procedures to be followed for breach of personal data, especially in Tanzania? This third question, I think it has a response. It's from Yuda Kavagushi. I would like to know if the law provides for offenses vis-a-vis data protection. The response from Rachel, thank you, Yuda, Section 19 of the Act say that any person who provides false or misleading information during registration or renewal commits an offense and upon conviction shall be liable for a penalty. This is one example. Another question from Raymond Cosmas. There are those sensitive data such as health data like HIV, malaria, etc., that are used outside of Tanzania by organizations. How do they protect it since they are personal data? Abdallah, there's a response from Abdallah Mgwami. My view, the data probably offers a general overview and does not directly affect a specific individual that is revealing personal information. Elena Ngalo, spot on Raymond, very pertinent question. Another question from Yuda, kindly provide a clear distinction between offenses in cybercrime against those committed against the personal data protection. I think there is a response from Rachel. Offenses in cybercrime or fuel happening on computers, internet, cyber tools, etc. Those committed against the act refer to personal data, image, voice, address, names, biometrics, etc., and can happen even in the absence of a computer or phone. Another question from Yuda Kavagushi. Can you explain data protection vis-a-vis information disseminated by the employers? For instance, thank you, Yuda. Response from Rachel. Do you mean the difference between personal data vis-a-vis information disseminated by an employer? Yes, of course. Another question from Raymond Cosmas. Most of the companies establish their own human resources electronic system to restore their labor information. Most of the system do backup the personal data. How do these data are protected being installed to previous employers? So I think I will end there, and Rachel and Fatma, you can respond to these. We have 30 minutes for this discussion session. Thank you.
So I think, Honorable Aisha, I will respond to the question by Mohammed on the NIDA, and specifically with it having certain personal information on the card. So if you read the Personal Data Protection Act, it provides for certain processing that the law permits in case another law has permitted it, or if there are other instances whereby the basis for processing that data is maybe for public interest. And when it comes specifically to NIDA, the process of collecting NIDA and the card is actually under an act. So there's an act called the Registration, I think, of Persons, or Registration, I think, of Persons Act, that actually actually speaks to registering people's identity and giving them a specific card. And I think in 2023, that it has a regulation. The regulation were amended, and the regulation clearly states the kind of information that will be collected during NIDA and the kind of information that will be on the card. I understand and I agree. I believe that is somehow a breach of, it will feel like a breach of privacy, having your birth date on top of a card. And I believe when NIDA started, I think we did not even have the data protection law in place. And currently, I think the government has a project on issuing certain IDs that are going to be called Jamii Number, which would ideally aim to cure somehow this problem. So there will be a number, a digital identity that every citizen will be given, and that number will be ideally what you use. So you will not be using your NIDA, your, maybe let's say your driving license, so you just have a number. And I actually hope that when they are doing this project, that even I think when you look at your NIDA card number, it also has direct link to your identity. It can easily identify you from your birthday to your location, those numbers and sequences. However, I did speak to a person who was involved in the project for NIDA. Just last week, there's a moot court competition specifically to digital identities in East African country. And so I did speak to a person who was involved in the project, and they did seem to have reason to why they did keep those privacy info, like birth date on the card, and they had done what is this called prior, like a study prior to doing it, and they have their reason. We might not agree with that. However, that is the response that I would say. But I hope from now on that we have the law that the government is aware of personal data protection and the need for privacy, I think they would improve in any ID and ensuring that they are trying to safeguard people's privacy information. And so I hope that does maybe answer that question. I think I will also answer the other question with regard to offenses in the Cybercrime Act and specifically to data protection. So ideally, especially when it comes to personal data, assume I go to the bank and I am giving them my information. They have not stolen this information. They have not illegally accessed it, but I give them my information for certain purposes, and they start using that information beyond the purpose that I gave them. It is not that they're committing a certain crime, no, maybe it's just another kind of processing that they're using. However, when it comes to data protection, that is already a violation on the principle of purpose limitation. Like if you're collecting someone's data, you're collecting them for a specific purpose, do not reuse without maybe asking for their consent. And ideally, if you look at data protection, I think it speaks more to consumer protection in how businesses are processing personal data, in how they are gaining benefit. The law in Tanzania allows for someone to commercialize their personal data because this big tech company, a lot of service providers, they're commercializing your data. You would not have that right under the cybercrime. You would not be able to claim compensation for certain acts by someone misusing your maybe voice, maybe under cybercrime. And so there are offenses that might fall maybe both in cybercrime and would be a violation under the Personal Data Protection Act, but there are offenses, and specifically when it comes to the kind of obligation a data controller and processor have that would not be featured in a cybercrime. And if you look at the whole data protection framework, it mostly speaks to certain principles, it mostly speaks to certain measures and standards that data controller and processor have to attain. And they're not cyber criminals, this data controller. Maybe you're required to notify a breach. It doesn't mean that's a cyber crime if you suffer a breach, because it might be another malicious actor who now breached your system, but then you're complying with data protection by notifying the commissioner. And if you don't notify, that's an offense. And so that is how I would maybe add on to what Rachel had already responded on. But I would just stress that data protection is quite critical, and it mostly speaks to individual, like people who are actually users or interaction. And then they normally say, when we speak about security, let's say cybersecurity, it normally speaks to businesses protecting themselves. So you might have your intellectual property, you might have your confidential information as a company, your business strategy. Normally business would secure them, but they're not securing them from a privacy point. They're securing them from a security point and for their own benefit. Like no business is carrying your individual privacy rights or data protection as something that they have to carry it on. If there were no laws, if there were no enforcement, people would be misusing your data, because no business carry that as their first priority to privacy, to data protection. However, with law, that is where the enforcement comes in, and that is where now institutions carry that role, and that is where offenses come in. I think I'll let Rachel respond on the other questions if I think.
Yes, thank you. Thank you so much, Fatma. And thank you, Honorable. And once again, thank you to everyone asking the questions. I did my best to respond to the questions in the chat section. And so now please do allow me to also answer the other questions that are still awaiting answers. So especially to Raymond, on your question about sensitive data, especially health data, I'm assuming with your question, you mean Tanzanian maybe health data that is collected here in Tanzania and then used or processed outside of Tanzania. If that's not what you mean, please do let me know in the chat section. But if you're talking about data that is being processed, or Tanzanian data, for example, that is being processed or used outside of Tanzania, this would take you to the part of the law that talks about cross-border data transfer, meaning information or data is collected here in Tanzania and it's transferred outside of Tanzania somewhere for processing, analysis, and things like that. So the law does talk about cross-border data transfer, meaning that there are procedures for it, there are specifications for it, and what needs to be done. Now, it is very important for everyone to understand that cross-border data transfer is about a data collector or a data controller taking this information and sending it to a data processor for processing outside of the territories or outside of the jurisdiction of this country or place where the information or data was collected. And so when that happens, the law specifically states that there needs to be an assurance, and you need to actually know that where the data is being sent to or transferred, that that recipient country or jurisdiction also has an adequate data protection law or data protection systems to ensure that wherever this data is being processed, there will be protection, there will be security on how this data is going to be processed. So that is very, very important to know. The law talks about the different types of data that can be sent, how long the processing can be done, and all other different systems like that. So that is just a very quick answer I'd like to give you, Raymond. And also what I'd like to also let you know as an example is think about also where data is being hosted, where it is being hosted. I really like the example you've given about health data, HIV, malaria, because think about what happened at the very beginning of this year with the USAID entities, where, for example, operations were closed and shut down in a number of countries where USAID was operating. I was talking to a researcher about this who said that for some other countries and entities, after the USAID closed its operations, closed offices, staff and employees were laid off, a number of that country's data was just gone and disappeared just like that after USAID closed and left and things like that. So you can imagine another part of the conversation that we should be having is, where is this data being hosted? Where is it being placed? Yes? Who is the actual holder or owner of this data? Because that is also very, very important to know. And it does say a lot about how much access we have to this information. What if we wake up tomorrow and Microsoft has just shut down or closed or hacked or been hacked? Imagine how much information and data Microsoft has, or Google. Yes, can you retrieve it? Will you be able to access or get it at all? So just very quickly, that was a response to your question. And I see Kelvin has been asking me to talk about privacy by design versus privacy by default, and on pseudonymization and anonymization. When we talk about privacy by design, this is a system. This is what happens when, for the data protection or privacy team, you intentionally incorporate and embed privacy into every aspect and every stage of the life cycle of your activities in data protection. From the moment you collect this personal data, from the moment you store it, you transfer it, this and that, you have already embedded privacy features, you have embedded privacy principles into it. Yes, and as we talked earlier also, and I believe Fatma may have mentioned this, there's a lot that we do about making sure that unauthorized access isn't being allowed to this information, that the legal rights and the legal protection of this data is also being respected. All of that is privacy. Yes, so privacy by design is that intentional embedding of your systems, of your program, from the very beginning into every stage of it. Now, the difference with privacy by default is more of a technical or a settings matter. And I'll give you an example. This would be something like once you create a profile or an account, by default, it already has that. Maybe your account is private. So you would need to go into the settings and make it public. Or, for example, you have certain applications where from the moment you download it or you bring it into your device, it already has by default maybe limited access to contacts or pictures or things like that, or even in some platforms or websites, automatically by default, by the time you join, it has limited audience. So this is what we mean by privacy by default, that it is already giving you a default feature of privacy that not everyone or not everything will have access to you, to your tools, and to things that you do. Now, when we talk about pseudonymization, this word gives me a hard time to pronounce sometimes. It basically means that it's a way of protecting data, and it basically means that instead of maybe, for example, if it's a name or a person, instead of putting their name, you would use something like, you would say maybe user 123 came to check in at our health facility and they're suffering from malaria, things like that. All right. And then anonymization is, as we see in different platform surveys, that you just make this information anonymous. Yes, there was a quote that Fatma had shown, and it was saying some really beautiful things, and then the word down there said anonymous. So you're not putting a name, you're not putting a title to this entity, you're just leaving it anonymous. So that is what it means in simple terms. This is a quote that was at the very end of the presentation. So this would be what we call anonymization. It's a word, it's self-explanatory as a word. I believe I had answered a number of questions in the chat section. If anybody would need more clarification, please do reach out. But maybe one other thing that I'd really like to highlight and pinpoint again was a misconception that a lot of people have. And I think this was a comment by, forgive me, I forget who put this, but it was a comment that said maybe that some people understand and believe that data protection is for big companies, big corporates, multinational entities, and that smaller businesses or smaller companies are not really affected, or data protection doesn't apply to them. Yes, there was a comment here somewhere about that. So I responded by saying data protection is data protection. As long as you are collecting personal data, as long as you're processing it, this law applies to you. The principles of this law apply to you. The regulations, the systems, the different plans and policies that Fatma was talking about, they also apply to you. So it's not just for big international companies or businesses, it's for every person, every entity that is working, that collects personal data and processes it. And even in the Personal Data Protection Act of Tanzania, in the definition, in the interpretation section, it does, when it talks about a data collector, a data processor, it starts by saying an individual, but it can also be an entity, it can also be a company. Yes, so it refers to anyone who works in this area. Thank you so much, Honorable. And thank you to everyone.
Maybe, Honorable, I'll just like to quickly respond to a question. Someone had asked, how frequent should you update your policies? So the good practice is you update your policies maybe sometimes annually, and also you check to see if there are any amendment by the law, or if there are any changes, then it's also a good time for you to amend your laws. So Rachel had mentioned the privacy programs. So I think every institution can just have that in place, that maybe every year we just check to ensure that nothing has changed, our policy is up to date and has accommodated all changes, or if any. And maybe depending on your processing might change. You might have a new business that you're going into, and now you're processing sensitive data or a certain category, so you amend your policy accordingly. I think maybe I could also quickly respond to someone's question who had asked how should companies balance the need for innovation and data-driven growth with strict compliance to data protection regulation. So I think there's a misconception sometimes when people hear about data protection, they assume that now companies cannot use the data. But actually, there are as Rachel was explaining, ways in which data can be used to the benefit of an organization without violation. And so Rachel spoke about how data can be anonymized, because at the end of the day, when it comes to personal data, it's ensuring that someone's identity is not able to be identified or being detected. And most of the company use their data for their own internal analytic, for their own research, and you can do all these things. So it doesn't mean that if you have to comply with the data protection law, you'll not be able to use your data, you'll not be used maybe to do research, you'll not be able, you can do all this thing. And so I think that's also important to know that the data protection is not a limit to the use of data or innovation.
Thank you, Fatma. We had 30 minutes for the Q&A. I think we have exhausted those 30 minutes. I know I'm a moderator, but there's a question from Kazim Tai on whether the judiciary is exempted from the act. So I would like to respond to this. Section 58 of the Act exempts the application of the Act if the processing of the data is held in accordance with any law or court order. Therefore, by implication, it would not apply to the judiciary. As such, the Commission is restricted from supervising the data processing operation of courts when acting in their judicial capacity. And this is mainly to ensure the judiciary is independent in performance of its judicial task, including the decision making. And publication of judgments is also a requirement of the Constitution in order to support the rule of law. However, for the interest of justice, the Chief Justice had issued Circular number 2 of 2018, which provides for the protection of identification of children in the adoption proceedings and victims of sexual offenses. You may notice in most of the adoption cases and victim of sexual offenses like rape, we use pseudonym in most cases. We don't mention the names of the parties. But now the question is, do we need to balance public and private interests? And should we go further to provide guidelines for other areas like probate? Because you have seen in some, or matrimonial or labor, you have seen in some matrimonial cases, confidential information, especially health information of some of the spouses is made public. In some of the labor disputes, some individuals have not been able to be employed because of the cases they have filed against their former employers. And with some probate cases, some of the spouses have not been able to find partners because of some issues which have been exposed. And you have seen also some of the victims of sexual offenses, example, rape, being victimized for multiple attacks. That's because they've had similar experiences of rape or other sexual offenses. But now we have recently observed some judges taking steps to enhance personal data protection by substituting actual party names with fictional ones in matrix. And these judges emphasize on the necessity of establishing adequate safeguards to facilitate the successful exercise of individual rights. So that's what I wanted to share. I think we should end here, but Fatma have provided a link to what association for those who are interested to dig further on the subject. You can join there and address some of the issues which we have not been able to discuss with the speakers directly because of the time constraint. So I'd like to thank you, the presenters, for such an insightful presentation, and to you, our audience, for your active participation. We have been with most of you from 3 p.m. to now. Please look out for our next Taula webinar. And as for now, you are all dismissed. It is so ordered. Thank you.
Thank you, Honorable.
Thank you, Honorable Aisha.
Thank you, Honorable.
Honorable. And you said it all. So from our side, the Secretariat at Taula, we want to appreciate you for taking us through, for your excellent stewardship of today's discussion, Honorable Judge Aisha. We appreciate a lot. And then we also appreciate Fatma, Rachel. Like I said at the beginning, Rachel and Fatma, you guys are my mentor and you keep on surprising me all the time. I appreciate you so much. And otherwise, what the judges said, we have more webinars that we are planning to host. So be there. And we also again appreciate this is the webinar we have had where members or participants have been very active. We have seen so many questions. So now it says that the moderators and the speakers were good, but at the same time also the topic was good. I think, and because this topic also touches us, in one way or the other, not only institutions, us as individuals. Thank you so much once again. Asanteni sana, karibuni.
Aya, asanteni. How do I get out of here?
Thank you so much jamani, tumepata madini mapya.
You're welcome. Karibu sana. Karibu. We're grateful.